Thank you, Dr. Chelvan, for giving this interview for the Inner Temples project, Race and the Legal Profession. I will begin by introducing you. You are the head of Immigration and Public Law at 33 Bedford Road Chambers, and you were named Legal Aid Barrister of the Year in 2014. You originally arrived in the UK aged 4 from Sri Lanka, and your name is a typical Sri Lankan Tamil one. S is the first letter of your father's last name. You only use the first letter, and Chelvan is your given name, used as your last name by which you are known. You've been an out gay man for the last 25 years, since your early 20s, and have built your reputation as a globally recognized legal expert on refugee and human rights claims based on sexual or gender identity and expression. You have represented clients up to and including the Supreme Court and European Court of Human Rights in Strasbourg. Your Chamber's website says that you have spearheaded some of the leading cases since 2005 in the field of LGBT+ asylum law, and have provided consultation to the United Nations, national government departments, and NGOs. You gained a first in politics and law at Southampton University in 1998. You were awarded a major scholarship and Duke of Edinburgh entrance award by the Inner Temple, and you were called to the bar in 1999. You gained pupillage at Doughty Street Chambers and 2 Garden Court, and during your pupillage year, you undertook an academic sabbatical, having been awarded a visiting research fellowship in 2000 by Northwestern University in Chicago, and as a Kennedy Memorial Trust Scholar at Harvard Law School. You were awarded an LLM in 2001, specializing in international human rights law and the lesbian and gay liberation movement. Returning to the UK in 2001, you established your practice specializing in LGBT+ asylum and human rights cases, and spurred by your thirst for academic research while practicing at the bar. In 2019, you were awarded a PhD in law from King's College London for your thesis entitled "At the End of the Rainbow, Where Next for the Queer Refugee?" I think you will agree that one of your principal accomplishments has been to develop a model known as DSSH, standing for Difference, Stigma, Shame, and Harm, developed in 2011, of open-ended, non-adversarial questioning that can be used to determine the credibility of LGBT+ individuals seeking asylum and make the required interviews less like an interrogation and less judgmental and intrusive. This model is used globally and has been endorsed by the United Nations High Commission for Refugees since 2012. Can you tell us a bit more about this model and how it has made a difference around the world?
Well, Amelia, what a fantastic introduction. Thank you so much for that. I mean, the model, I am proud to be an activist lawyer, and I'm very honored to be a member of the Inner Temple, without which, through the Major Scholarship Award and through the support throughout, and I'm sure we'll talk about that later on, have been instrumental in my ability to thrive at the bar and be visible. So as an activist lawyer, I sort of try and intertwine the issues between legal, academic, and my policy work. So from 2004 to 2010, the Labour government through the courts introduced what was called a discretion test. So if you were lesbian, gay, or bisexual, whilst it was accepted that your identity in relation to your sexual identity, and it was accepted that your country of origin would persecute you because of your sexual identity. If I point a gun towards you, Amelia, would you go towards the gun or away from the gun?
Away.
Absolutely. And that's what the discretion test was about, is that the majority of people, if they would face persecution, would go away from the harm. So the test was developed from 2004 in a case called Z in the Court of Appeal, from an Australian High Court case in 2003, was that 2004 to 2010, the test was, is that discretion reasonably tolerable? So the first case I litigated as sole counsel in January 2006 in a court of appeal called RG Columbia, even though my client was accepted to be gay, was accepted that the vigilante death squads in Colombia went around and exterminated and killed extrajudicially gay men, trans people, prostitutes, those were not acceptable. And even though we had medical evidence that any form of discretion would cause my client a breakdown, the Court of Appeal said, no, that's not enough. That, you know, gay, lesbian people, bisexual people were returned to these countries of origin. And 98 to 99% of refusal letters were relied on the Home Office, not on rejecting the credibility of the individual regarding their sexual identity, but on the basis that it would be reasonably tolerable for them to be returned to the country of origin. So in July 2010, a major case in the Supreme Court called HT Iran and HT Cameroon, and I was very honored to be HT Cameroon's junior counsel in the Court of Appeal. What the Supreme Court said in the landmark judgment, which is still the framework for all protection claims in the UK, was that, look, no straight person would find it reasonably tolerable to be discreet. So if a person is discreet because of their fear of persecution, then they're granted refugee status. However, if persecution is not one of the reasons, so it's only social pressure, name calling, whatever that may be, then Lord Roger, paragraph 82 of the guidance, made it quite clear that the individual could be rejected from asylum. So since 2010, one of my strands of my litigation, strategic litigation, is to get rid of the discretion test. But what happened was, following the judgment in 2010, exactly what happened in Australia following S395 in 2004, was that the Home Office moved from discretion to disbelief. So having accepted that these individuals were lesbian, gay, or bisexual, the Home Office started to produce decisions that will prove that you're gay. Now, the question is, how does somebody prove that they're gay? How does some person prove that they're straight? So at the time, I just started my PhD research at King's in 2008. I thought there's got to be a way, and that's what transported my litigation mind into my academic persona. So I said, well, we've got to create some sort of model to try and address it. So in April 2011, I was asked by the ELNA, the European Legal Network, to provide training. And I thought, what are the concepts? What makes the queer refugee? And I looked at issues of difference, because if it wasn't for the difference of the refugee, they wouldn't suffer persecution. So, and the stigma attached to that. So I looked at my own journey, my own emotional journey as a queer man who realized I was different when I was 14 and had that light bulb moment. And then looked at my history regarding my gender nonconformity as a child. And my lack of ability to adhere to the stereotypes of what a straight person would be. And so I developed the concepts of difference, stigma, and shame and harm. And then in June 2011, I was invited by UNHCR to attend a meeting in Geneva of NGOs, and a representative from ORAM, a US organization, said, look, with UNHCR, they said, look, we need a questionnaire. We need 40 or so questions which we can give government officials in order to be able to prove gay. Now, I think you've only met me for 10, 15 minutes. I'm not exactly a shy, retiring wallflower type. So I immediately shouted up and said, absolutely no way. Because I knew how the Home Office approached this with Somali minority clans. You answer 15 out of the 40 questions correctly. You're not Somali minority clan. You answered 39 out of the 40 questions correctly. You've learned the answer from the internet. So I said, absolutely, no, we can't have questionnaires. What we must have is trigger questions, enable the refugee to be able to tell their story. So that's why I created the model, because my role as a barrister is twofold. Firstly, as a storyteller, I tell my clients stories. And secondly, as an interpreter, to interpret their stories into what the foreign language we call the law. So the first thing is to create that safe space so the individual, through these trigger questions, can go through a narrative of different stigma, shame, and harm. And it is not primarily as a credibility assessor, but as a positive tool. So for example, there will always be exceptions, those who do not fit the narrative in relation to their emotional journey. So that's why it's very important to stress that the way the Home Office has sometimes used the model, and they've adopted the model in 2014-15 after the Independent Chief Inspector of Borders and Immigration recommended the adoption of the model in his review of the Home Office approach to sexual identity claims after the harrowing tales of intrusive irrelevant questions on sexual practices, Home Office immigration officers were asking gay asylum seekers. Questions such as, what attracted you to a man's backside? That was reported in The Observer in February 2013, and other sexually explicit questions. Is that, you know, from the adoption of the model, it's there as a positive tool. So I created the model in 2011. As I said, as you said, UNHCR actually invited me to a roundtable of 23 government officials in Geneva the week they referred to, I hope you can't see that pop-up window, the same week as they published the International Protection Guidelines number 9, where paragraph 62, they referred to the different stigma shame. I was an external expert consulted for that. And, you know, so from then, New Zealand, Sweden, Finland, Norway, governments around the world, fast forward to now, it's adopted, you know, by UNHCR in 2012. UNHCR and the IOM use it for all their global training in 2015. I gave some training to Hong Kong officials last September and November. Canada uses it. The European Asylum Support Office uses it not just for sexual identity claims, but also gender identity claims. I don't have copyright. Sorry, I have copyright. I don't have trademarks. I don't get royalties from using the model. But those people who've used the model, my only solicitor last week told me, I use your model, my clients get asylum. So that you know, the reach is, you know, of course there are critiques of the model, and it's quite interesting as a lawyer and now as an academic, and I work in policy. You know, it's an honor to have fellow academics criticize the work I do with published journals. You know, if you asked me 20 years ago, would I have academics referring to me in journals, I would be very surprised. But, you know, it's going through rigorous critique and analysis. And the most important point is that the refugee is able to be in a safe space and tell their story in order to be able to gain safety and refugee status.
Right. Well, all that shows the impact your work has had at a global level. So wondering what you think you've accomplished generally at a global level.
Well, hopefully the ability for decision-making judges to be able to understand what it is to be different. Because there was, when I started as a pupil, as you know, I came back from Harvard in 2001, and you know, Harvard was an amazing opportunity for me to be able to really explore academic issues and engage with the points. I mean, English legal education was very formulaic, A plus B equals C. Where Harvard gave me the opportunity to say, look, you want to get to the letter G, as a lawyer, you invent the formula. And that revolutionized my approach to the law. So when I came back, it's all about sex. You know, the cases were, the classic Iranian gay case was, you know, you're discovered by the Basiji, the religious police, in your bedroom with your boyfriend, and you run out on top of the roof and you jump off roofs to be able to escape. And there's a huge climate of disbelief by not only the Home Office, by judges in relation to this. But what they said in effect is that, well, as long as you can conduct sex in the privacy of your home, then you're not really going to suffer persecution. 1989, a case called Bimbasi, but you know, a Turkish Cypriot case, you know, Mr. Justice Kennedy said, was presented with arguments, with submissions by the Home Office, which said, look, sex is something you can refrain from. You're only going to get in trouble if you have sex. So on that basis, the Refugee Convention doesn't protect individuals who can refrain from sexual acts which will place them in a position of persecution. Now, you know, you're filming me. I'm here in my study, in my home in King's Cross. I'm, you know, my husband and I have been together for over 20 years. Civil partner Dan married at Inner Temple, first civil partnership ceremony in June 2006, and upgraded with marriage. And my life, unfortunately or fortunately, it's not just about sex. You know, I go out of this study door, I go out of my apartment, and I go into the outside world. And, you know, I don't prove that I'm gay by having sex in front of a third party. You know, I talk about my love, my emotions, the Joji Carter principles, affections, emotions, and conduct, which goes to the issues of identity. So for me, it's about giving the opportunity for the refugees' voice to be heard. You know, my USP has always been for many years to be the mouthpiece for those who know the words but have no voice. And a person as a queer person, as a person of color, as a first generation immigrant, as somebody who lives with a disability, who predominantly went to state schools, who didn't go to Oxford, but my issue is in relation to being able to stand up and change the law, be an activist lawyer to empower others. So for me, it's about providing that voice, providing that moment, and being visible.
Right. And how do you think things have changed for LGBT plus asylum seekers? I think you use a different expression rather than asylum seekers in recent years. And how do you see the road ahead for them?
Well, I deliberately don't say asylum seeker. I mean, Dronke Parter, one of my very amazing friends and colleagues, and she's training to be a barrister. And she, was disbelieved by the Home Office for 13 years, and we used the Dish model to provide her a voice, and she got asylum in August 2017. But in her case, she's part of an organization called African Rainbow, which she set up, and she says, look, you put the individual in as an asylum seeker, and then they take the whole identity of the asylum system. So a person seeking asylum, but the human before the system. And the major issue is not only credibility assessment, but I was invited by the Independent Chief Inspector to do a review as an independent reviewer on Home Office country reports on sexual orientation, gender identity, and I ended up reviewing 31 Home Office country reports. It's an over 400-page report. You can get it on the Independent Chief Inspector's website. And I provided 10 recommendations, 6 of them which were fully accepted by the Home Office, 2 partially accepted, 2 rejected. And we're talking about engaging with the Home Office with accurate decision-making. Today, the 18th of August, the Home Secretary has announced last night the bespoke Afghan citizens resettlement scheme. Whilst it's a starting point, 5,000 refugees in the first year by the end of the year, those people who are left behind, they don't stop being persecuted until 2 years from when they can come and be resettled. So it's very important to have accurate country information. So the other issue I have is in relation to the Home Office Country Policy Information Team needing to provide accurate country information. So I've done many cases. I've done a big case in relation to a Kenyan rugby player called Kenneth Macharia last month, where the Home Office country report said Kenyans don't suffer persecution. First year tribunal judge disagreed. In Sri Lanka, they said no prosecutions. They now accept 1 prosecution. The evidence shows 18 prosecutions in 2018 of gay men. And now, in October last year, anal examinations and vaginal examinations of those perceived, that's a trans man, of those perceived to be gay by the judicial officers in Sri Lanka. So it's very important that the Home Office improve their decision-making to ensure that queer refugees are treated with sensitivity and with decision makers who are aware of the full picture of the narrative behind the claim.
Right, that's interesting. And turning back to your own career, what obstacles did you face at the beginning of your career due to your ethnic origin, and how do you think things have changed since then?
Well, it's quite interesting because, as I said, I'm first-generation immigrant, so I'm very proud of my immigrant narrative. And for me, one of the major issues is in relation to the fact, and that's why I use people of color as a person of color rather than ethnic minority, because there's no way I can be invisible. Can I pass for a white person, a Caucasian person? So I've been very fortunate that I was very driven early on in relation to the areas of law I wanted to do, and I was successful in gaining pupillage in the first round of pupillage interviews when I applied. But the main issue is to be able to go beyond the stereotype. So it's very easy, especially, these were the late 90s, just when Stephen Lawrence inquiry was happening, is that because of my perseverance and drive and passion for the law, the bar is a fantastic profession which recognised meritocracy and those who are passionate advocates. So because I had successes in cases, that provided me a lot of peer recognition. But for a lot of people of colour who went to the bar at that time, definitely, and still at this time, especially in the more traditional commercial chancery areas, there were a lot of obstacles. I know ComBar and a lot of the specialist bar associations have been doing a lot of work, but the major issue is to be able to break outside the stereotype. And, especially in the asylum field, as a person of color who's a Tamil, the backstory is basically, my father brought my brother and I here in 78 to flee persecution because of anti-Tamil rights in Sri Lanka, 77, 78. My mother was already here on a visa as an anaesthetist doing some postgraduate work, so we were able to piggyback. So the point is, as a person of color, as a Tamil working in the field, that brings up more sometimes stereotypes and a lack of understanding and appreciation of what it means to work in the field. So for me, that wonderful Francis Bacon quote, Thomas Hobbes, knowledge is power. So I've used my soft power throughout my career to be able to break down those barriers, to overcome those barriers, to be able to advocate for my clients in order that they succeed. So for me, it's about, breaking through the stereotypes, being visible, and using knowledge as power.
What do you think needs to be done to improve the ethnic diversity and inclusion within the legal profession?
Wow. That's a report in itself. Well, no, well, as I said, visibility, more of us need to be visible. I'm very fortunate to be, at the end of November last year, to be asked to join 33 Bedford as Head of Immigration and Public Law. I'm one of the founding members of an organisation called the Association of British Tamil Lawyers, which is a very exciting project to be invited to be part of. So it's about ensuring that we create safe spaces for people of colour who are in the legal profession, but also being able to signpost. I know, when we look at the judiciary, it's 2021. We have no single member of the Supreme Court who's a person of colour. You look at comparable courts such as the US, there's a history behind that, and other countries as well. In the Court of Appeal, we only have one Court of Appeal judge, Lord Justice Singh, who is a person of colour in the Court of Appeal. In the High Court, we're starting to get a change. There's Justice Chowdhury, there's Justice Kima Grubb. We're getting about 4 or 8 people of colour who are judges at the moment. And I know the Judicial Appointments Commission are doing a lot of work. But I think what we need to be able to look at is, how much longer can we wait to have a representative judiciary, especially in London, where over 40%, 50% of the population are from, born or come from an ethnically, different group rather than Caucasian. So quotas is something which I've always, lobbied for. And the argument against quotas is that, an individual who is a person of colour may be told, well, you've only got there because of the colour of your skin. And I think that's a rather redundant narrative to be concerned about, because that's already been happening. That's already been said about other individuals in other positions, which is unmeritorious, because these people have clearly worked hard. They're clearly making a difference. But within the legal profession, we've got, I believe in intersectionality. Intersectionality is a phrase created by Kimberly Crenshaw, who's a professor in New York, who talks about the fact that I just don't have one identity. So it's very important to be able to understand the intersections about race, ethnicity, sexual identity, gender identity. That's a huge area which has unfortunately been very misunderstood by those who wish to exclude trans, non-binary, and gender fluid people from our society or our spaces. So disability. So it's important that to have a more representative legal profession, we need to, and we are engaging with intersectionality and awareness of that. I'm very proud to be part of the Inner-Temples Equality, Diversity and Inclusivity Subcommittee, to be able to do the work. Free Bar, it's an organization I've been involved in since its foundation. So to be able to go out there and be able to affect change. So, quotas in some areas of our profession, dialogue, allyship. Allyship is exceptionally important for those who have and possess privilege, to be able to create spaces for those who aren't always heard to be in that space, to be in that room, to make the decision making. So these are all different facets which I think are starting to be deployed and should be strengthened even more in relation to advancing the diversity and inclusiveness of our profession.
Well, thank you very much, Chelvan. That's all been very interesting, and I think people will be very interested to hear what you had to say. So thank you very much for your time.
Thank you.